So contracts unit 3, we were discussing performance of contract, right? So in general, when there is a contract between two parties, parties need to perform the contract. That's like the main reason why parties have entered into the contract. So whenever there is a contract, parties need to perform the contract unless and until it is something which becomes impossible to perform, right? So parties are bound to perform their contractual obligations, whatever is binding on them. But many a times, due to unforeseeable circumstances, when we enter into the contract, we could not foresee that this might happen tomorrow, that might happen tomorrow. Okay, so because of these unforeseeable circumstances, sometimes it may happen that performance becomes impossible. Even though we entered into the contract, even though we had contractual obligations, performance of those obligations become impossible at a later point in time. In such cases, we say that the contract is frustrated, frustration of contract, which is dealt under Section 56 of the Act. Okay, so Section 56 of Indian Contract Act deals with frustration of contract as being acts which cannot be performed. You entered into a contract, you made some promises, but later on it becomes something that cannot be performed. Under this doctrine, a promisor is relieved of any liability under a contract in the event of breach of contract, and the contract will be deemed to be void. Because it is something which you cannot perform, the parties are released from their liabilities. Whatever liabilities you have, you are released from it because it's something that cannot be performed. And because it cannot be performed, the contract will be considered as void. Okay, and this concept is based on a Latin maxim, les non cogit ad impossibilia, which means law will not compel a man to do what he cannot possibly perform. Something which is impossible to perform, definitely law cannot impose that upon the parties. Okay, but where and all frustration of contract applies, it applies in two cases. If the object of the contract has become impossible to perform, for whatever purpose, whatever reason the contract was entered, that object itself has become impossible to perform, or an event has occurred after entering into the contract, after parties enter into the contract, some event has taken place making the performance of the contract to be impossible, that to beyond control of promisor. Promisor has not made it impossible to perform or something. The situation was such that beyond control of promisor, something happened and it is impossible to perform. It has become impossible to perform. Okay, so there are certain conditions which are necessary for application of Section 56. These are that there exists a valid and subsisting contract between the parties. What can we enforce in the court? Only a valid contract can be enforced, right? So for frustration also, it has to be a valid contract. Otherwise, it would be like, okay, there was some sort of a promise, but it's not a contract, right? Their frustration is not going to apply. So for Section 56 to be applied, we need a valid contract plus a contract which is still continuing, as in which is yet to be performed. Not like something is performed, contract has ended, their frustration is not going to apply, but it will apply wherein there is a valid contract between parties and this contract is still continuing. It is yet to be performed. Contractual obligations are not fully satisfied yet. There must be some part of the contract which is yet to be performed. It might be that the entire contract is yet to be performed, or maybe some parts within one contract which is yet to be performed. And that becomes impossible at a later point in time, wherein we can say that Section 56 is applied. The contract, after it is entered into, becomes impossible to perform. Initially, when parties entered into the contract, it was all fine. Okay, otherwise it will be like specifically void only, right? That you knew that this is impossible to perform, like plucking stars from the sky. If I make a promise that I will pluck stars from the sky for you, it's something impossible, everybody knows it. So it's void from the very beginning only. It is like specifically void. But it has to be something that initially when we enter into the contract, it was all fine, all good, but later on it becomes impossible to perform. There, section 56 will apply. Okay, do you remember there was a list of situations wherein contract would be considered as specifically void? After essentials we discussed, like essentials for formation of a valid contract. Even if you are satisfying the essentials, there was a list being provided wherein contracts will be considered as specifically void. There, this was also there. That's something which is impossible to perform, like plucking stars from the sky, discovering some hidden jewels by magic or something like that. All these are impossible to perform. So these would be specifically void. But here it has to be something initially it was fine, later on it becomes impossible to perform. Generally, frustration of contract can be in following cases, like death or incapacity of a party. If parties to the contract itself dies and it is something wherein responsibilities cannot be transferred or contractual obligations cannot be transferred to another person, there we would say that it is something where frustration of contract would apply, right? Might be you have hired a person who is very good in making portraits, okay, and you have given him a picture that this portrait you need to make. If the person himself dies, who was a painter, definitely that cannot be transferred to his son, daughter, or someone like that, right? So their death makes it impossible to perform. Initially, when you entered into the contract, it was all fine. Later on, the situation is such that it becomes impossible. Same ways, it may be incapacity of the party. Party only becomes incapable of performing it, right? Might be you have hired a piano artist for some event, okay, and all the agreement, everything was done. On the day of event, the artist becomes sick, okay, to a great extent that she is not able to perform. In such cases, we would say that it is incapacity of the party to perform. The party is in a situation beyond her control that she is not able to perform it. There also frustration of contract will apply. Okay, so death or incapacity of party wherein it's not possible that we expect the other person to perform the contract. Frustration by virtue of legislation. So it might happen that the party died, the party became sick, or might be that she got injured or something like that, where it becomes impossible. Sometimes it may be because of some law that is applicable. Okay, because of some law, it becomes not applicable. So where new laws are framed, right? We see amendments are being made, new laws are being introduced, new rules and regulations are being imposed. There also it can become, we can say section 56 applies. This happened a lot during COVID. Okay, might be there is a contract between you and me wherein I have said that I'm a company who helps in transportation of goods from maybe one state to another state. Okay, so there is a contract between you and me wherein I have said that on so and so date I will transport these goods from this state to that state. Okay, but now because of COVID, lockdown is being imposed and this transportation from one state to other state is being restricted. There I would say it is frustration by virtue of legislation or by virtue of law. Notification is passed from the executive whereby there is complete restriction on import and export from one state to another. There it's not within my control, right? It goes beyond my control. So there I will say that contract is frustrated because of some law that applies. All right, sometimes it may happen that a person said that I will supply you 1,000 liters of so and so oil, but now there is a legislation which imposes restriction on the quantity, maximum quantity that you can sell, maximum quantity that you can export. There also we will say because of so and so legislation there is a restriction, I cannot do it. Okay, so a legislation or a law also might make a certain thing impossible to perform. There also section 56 will apply, because laws keep on changing, new laws keep on coming. Everything we cannot predict at the time of entering into the contract. Sometimes it may be frustration due to change of circumstances or change of situation. Okay, this particular situation deals with those cases where there was no physical impossibility of performance of the contract, but because of change of circumstances, the main purpose for which the contract was entered has been defeated. So because of change in circumstances also, sometimes it might happen that the contract becomes impossible to perform. Okay, maybe within an entity or an organization, a person was having the like the authority or the ability of entering into contracts, making the organization liable. Later on, it turns out that the person got that authority by way of fraud or misrepresentation. He is being removed. Then also we can say that there is change in circumstances. Now it becomes impossible to perform. Okay, so there might be a lot of different situations wherein performance becomes impossible at a later point in time. There, section 56 is going to apply. Okay, is it clear till here? Then we have something called as initial versus subsequent impossibility. Okay, impossibility is there, but it may be initial or it might be something that comes subsequently at a later point in time. So, initial impossibility. The object of making any contract is that the parties to the contract will perform their promises. Whatever obligations they have, they will perform it. And where the contract is impossible to perform, parties would never enter into it. When you know that this is something that cannot be performed, you should not even enter into the contract. Like, I should not enter into a contract that I will pluck stars from the sky for it, because I know it's something which is impossible to perform. Initial impossibility deals with those cases wherein contract was impossible to perform from the very beginning itself. The moment I entered into the contract, that point in time itself, I knew that I cannot pluck stars from the sky. Still, I should not enter into such a contract only because I know it cannot be performed. For example, if a married man, knowing that he cannot marry again with his spouse being living, promises to do so, then he is bound to compensate the other party. Okay, so if I know that, okay, it's something which I cannot perform, even then the person is doing it, then this is something which is known as initial impossibility. Okay, initially itself, the contract was impossible. But for section 56 to be applicable, it has to be subsequent impossibility, wherein later on it becomes impossible. It deals with cases where contract was possible to perform when it was entered. But because of some event, because of change in circumstances, because of change in law, performance has become impossible or unlawful. And therefore, it discharges the party from performing it. Party is released, that you need not pay compensation, you need not perform it. You are released from your contractual obligations. For example, if A purchases tickets from B for watching a cricket match and he pays 50% as an advance, if the match is cancelled, then A cannot recover from B as the cancellation of match was beyond control of A. Right? So these sort of situations do happen, which is nothing but subsequent impossibility. It becomes impossible to perform the contract. Many times you will also see when you book a venue for some event, they will say that it's something which you cannot cancel. Even if because of some reason you cannot organize the event on that particular day, you cannot cancel it or you cannot get a refund. Okay, so this doctrine of frustration, right, it's applicable in subsequent impossibilities only, wherein initially it was all fine, it was all good. But later on, the situation becomes something wherein parties are not able to perform. Moreover, this doctrine will also not be applicable in cases where there was a mere delay in performance of the contract and the contract can still be performed. There it's not going to apply. Sometimes you might see that because of COVID, there may be delay in performance of the contract, right? Parties might say that we require some time. Maybe you can say this construction works, building of apartments, etc. There was huge delay during COVID. So there it's not like it becomes impossible, just that because of COVID, because of the ongoing restrictions, there is like bit of delay in performance of the contract. But still, it's possible for parties to perform it. So there it's not going to apply, but where it becomes impossible, there only it will apply. Okay, so builder cannot say that under section 56 it has become impossible to perform or something. There is just a delay. Okay, performance is still possible there. So doctrine of frustration is mentioned under section 56 of Indian Contract Act, and it deals with those cases where performance of contract has been frustrated and the performance of it has become impossible due to some situations which are unavoidable, which could not be foreseen at the time of entering into the contract, and which are ideally beyond control of the parties. Okay, it just happens. This doctrine is treated as an exception to the general rule, which says that if there is breach of contract, you need to pay compensation. When you enter into a contract, you either perform it or you pay compensation. So section 56 is like an exception to that general rule. But it will deal with cases of subsequent impossibility only, wherein its situation is beyond parties' control and it becomes impossible to perform. Not like some delays there or something, there it's not going to apply. Okay, is it clear?
Yes, ma'am.
So frustration or impossibility of performance we have.